Good afternoon. It is April 23, 2020. I am Lisa Speaker, and we're here on a What is an Emergency in Family Law Cases webinar. I have with me on panel today, Oakland County Circuit Court Judge Jacob Cunningham, Family Division, Tara Pearson at Parker & Parker in Livingston County, and Donna Medina, who is at the firm of Williams, Ratner, and Plunkett in Oakland County, and she's a private practitioner as well. So thank you, all three of you, for joining us today. And I'm expecting that we're going to get a lot of feedback from our participants who are in other counties, because right now we're covering, the panel has Oakland and Livingston County. I know there's a lot of other people from around the state, and we'd love to hear if you have input about what your counties are doing as well. And it does sound like now that we're, what is this now, 5 weeks into a shutdown, it does seem like a lot of courts are starting to figure out how to have hearings by Zoom. Some counties were slower than others, kind of getting up to speed on that. But even right now, we're starting to have more and more counties who are making it more accessible. But we still have a long ways to go, and hopefully not too much more time at home. So today's the topic is, what is an emergency? And this is something I've been thinking about for a long time, partly because I get a lot of calls about it, and I get calls and people want to file a motion, but they can only get into a particular courtroom if it's an emergency, and they're like, what happens if it's not deemed not to be an emergency? Are we left without a remedy? So there's a lot of questions that have arisen from that, and SCAO and the Supreme Court have issued some materials about things that are happening during the coronavirus shutdown, but there's really not a whole lot of guidance out there about, or any guidance about what is an emergency. So we really need the input from our panelists to share their thoughts, and obviously people who are in the audience as well. And if you're coming from different counties and you want to put something in the chat, let me know what county you're in as well. So first I was gonna poll the panelists to see if they had some initial thoughts about the topic of what is an emergency. Let's go ahead and start with Judge Cunningham, and I know he was very gracious and polled his colleagues at the Oakland County Circuit Court. So we're loving to hear from you about that.
Okay, well, I guess as far as what is an emergency that we're seeing right now, as a starting place, I'd say this. There's kind of two categories right now of what's an emergency as far as where we all are in the world during this pandemic. Things that were an emergency prior to March, I forget what day it was, March 10th or 17th, something like that, that would be otherwise deemed an emergency that we'd expect somebody to take court action on. And then what is an emergency based on the special circumstances surrounding the COVID-19 pandemic? Kind of two categories that we're grappling with right now. And in light of that, what are the procedures that are in place that to address both categories of emergencies? I did ask my benchmates about what they view things to be in emergencies, but the general consensus is pretty much not much has changed, except for if there's facts that relate to the COVID pandemic being something that creates an emergency, or something that in light of the stay home, stay safe orders has changed what might be an emergency. So with that small exception, unless someone's on fire or there's a serious risk of immediate or irreparable harm, that is going to be, that's what we're looking at for emergencies across our bench.
Did you say, Judge, like irreparable harm? So it's more like, almost like a higher, like the ex parte standard, the
yeah,
temporary restraining order type standard? Okay.
Yes, if it would rise to the level of a temporary restraining order, the standard you'd kind of apply for issuance of a personal protection order is helpful in terms of guidance as what would be something for an emergency under these circumstances. Irreparable harm that can't be addressed until you can get into court is the starting place. Is this something, most judges start with, can I deal with this later? Is this something that requires me to drop what I'm doing to make sure that someone's going to be protected, life and limb going to be protected? That's something that gets our attention.
So Judge Cunningham, I just want to ask, because I think Oakland County, a lot of the judges are holding hearings now. So it's not there's still a way to have a hearing in front of a family law judge in Oakland County, or I don't know if that's true for all of them. But it doesn't necessarily have to be an emergency to get a motion heard at this point.
Correct.
Am I correct?
Okay. I just got off the bench myself a few minutes ago. Actually, I've been in hearings all morning. We are doing hearings consistent with the judge's discretion in terms of what we're going to hear for motions, standard motions versus emergency motions. I guess speaking for myself, and I can also speak for Judge Brennan, as I'm sure most people on this would know, that I was her staff attorney until I was elected and started on the bench in early 2019. If you submit an emergency motion to our court, we're going to hopefully get an order out in some degree within 24 hours, 24 business hours. Now, when I say some order, that could be a grant, it could be a denial, it could be this is an emergency, set up for hearing. But as it relates to addressing the emergency aspect, especially in the chambers that I'm familiar with, you're going to get some sort of an order telling you the direction of the court. Again, the order could very well be, this actually is not an emergency. We'll see you at motion call or see you on Zoom, as the case may be right now. But that's where we are. Now, as far as the judges are having discretion to do hearings versus on routine matters, that we would probably be more inclined to have in open court at this point, since we got that direction from SCAO a couple weeks ago that we should be trying to do as much as we can in terms of regular business, as long as we're honoring the stay home, stay safe order. As far as, I guess I'll say for my own personal policy, and I know it'd be more helpful to everyone on here that could be more universal for all the judges, but I can really only speak to for myself on some of these things. If there's attorneys involved, I'm much more able to set up a Zoom hearing. I know Wayne County is going all Zoom on all matters, including all pro pers. That's, if they can do that, that's great. I think we're trying that as much as we can. But there's challenges with pro pers in terms of, it's the same people that can't really even get to the courthouse. Do they have an iPad with a camera that's going to work, that's going to be able to set up Zoom and an internet access? I mean, it's the same kind of type of limitations that might be there. So we're trying to do as much as we can within reason right now.
Okay, thank you. And Donna, you practice in a couple different counties. Do you have any input or insight from the other counties you practice in aside from Oakland County?
Okay, so so far I have filed 3 or 4 emergency motions that I thought would probably be granted, but I wasn't sure. So what I tried to do was write in the first paragraph, right on the first page, say what the emergency is to differentiate it from something that can be handled later. In my situation, two were addressed by Zoom and 2 weren't. And the ones that weren't were the surprises, because I thought that they were the more urgent matters. So what, as an alternative to that, one involved a child, and a child had made an allegation about being in the middle of a domestic violence situation during a parenting time. It was a younger child, and so couldn't be 100% sure about what was being reported or if it was valid or not. The judge did not think it was an emergency and said that it would be addressed at the review hearing, which was some 10 weeks later. So after thinking it over and talking to some of my colleagues, I didn't think I could really let that go and sleep well. So I decided to call CPS, just their regular intake line, and tell them what I had been told, and that I would not have considered this to be a CPS matter or even consider calling CPS, except for that I tried to go through the court system and use the judicial intervention, and I wasn't able to do that due to the status of the court. So I don't think that CPS thought it was an emergency either, but it was okay for me because I was able to go to sleep and know that I had done everything that I could. Another situation though that that was denied had to do with a financial situation, and I wouldn't have thought that that would be an emergency usually either. But young children are involved, and the mother was a stay-at-home mom with no source of income other than what she had from her husband, and there'd never been a problem before, the credit cards and all that stuff, and all of a sudden all the credit cards were discontinued, or she was removed as a user, and she had absolutely no way to get around because he took the car and confiscated that too. And it was all about filing for divorce. So, you know, I don't really know what to do in a financial situation like that. I would think that it would have to be pretty grim before
did you
would
get
consider
relief
that
on
to be
that
an
motion?
emergency.
Donna, did you get relief on that particular motion?
No,
Okay.
but I have a backup plan for that too. What we're going to do is go to mediation.
Okay. And then if we can turn to Tara for a minute so she can tell us about Livingston County. And then I know there's a lot of people who are posting some comments, and we have specific different examples of factual scenarios and whether it qualifies as an emergency or not. So Tara first.
Well, ironically, my problematic cases have turned the other way during this crisis. So I don't know what happened with that. The only questions I've been getting from my clients are from when the other parent is a first responder and they have concerns with then that parent being exposed and coming back and being around the children, and if it's an emergency to change parenting time. I tell them from kind of a common sense standpoint, there are measures that you take to keep yourself safe. If you weren't divorced, you would be doing this together anyway. So it's not a basis just of itself to do anything with parenting time just because they're a first responder. And I've had some conversations with other people in the community that have kind of indicated the same thing. Follow the order. This 14-day stay home that they want you to do is not a crisis for parenting time. As far as other emergency motions, I have asked around, and in the circuit court, it's judge by judge. If they decide if they think it's an emergency. I know that one of our judges, Judge McGivney, is doing his domestic docket, not just emergencies. He's doing motions and pretrials. So he's moving things along, and that's fantastic. The other judges, I really haven't heard anything other than the criminal requirements for arraignments and in custody cases that have to be moved along because of that timeline. I have actually had some emergency probate matters, and in the probate court, the only things that are being heard are emergencies relating to guardianships or the NA juvenile docket. And I know the juvenile is hearing emergencies when it comes to child placement and those type of things. And I do know, because I've observed Zoom was open, wasn't private at the beginning, and I have observed several pro-per people doing that by their phones and whatnot. The front of the court, I have been doing telephone hearings just on the normal motion screening, and I am hopeful that they switch to Zoom soon. The telephone hearings are a little frustrating as far as not being able to see people and my client not being able to connect just because I have a telephone issue. So I'm hoping that they move over to the Zoom, but they are moving along, which is very good to hear, because I know the front of the court in particular down in Livingston County has a huge docket amongst all of them.
So I want to share.
Lisa, quick.
Go ahead.
Okay, I just want to add one thing that just popped into my mind too. And I'm not sure if the folks on this know this or not, or what, how big this has been disseminated. I've been letting everyone know in all my hearings that as of the last day or two, SCAO in the Supreme Court has requested the trial courts or any court doing Zoom to either post it on YouTube, do a live broadcast, or have those hearings made available on a videotape under the court's website or something like that for some time. So, for both everyone's edification that these things are going to be public. The reason why they want us to do that is just so that there's access to the courtrooms, as if you could walk into a courtroom. They want to make sure that these hearings are accessible to the public in some meaningful way, which is why the judges are given an option of either YouTube, a live stream on YouTube, or a posting of the video of the hearing for a day or two. That's also occurring right now. So for clients that are walking around their house during a Zoom hearing, or there's just some privacy issues with that. So I would suggest you let your clients know before they get on a Zoom hearing with a judge or referee that those are going to be made available on the internet. And I certainly want to make sure people are aware of that before they start saying things that might be feel comfortable saying in court on a transcript, but it's different when they know it might be on YouTube or a video recording that anyone can access. So I just want to let everyone know that too, just so that they know that those videos are going to end up where they're going to end up.
That is extremely helpful, especially since a lot of us represent children. And I know when I'm at the Court of Appeals, they do audio. They've been doing audio recordings for a while, but they've been telling us ever since they've been posting them online is that do not use a child's name, just use initials. And so it's kind of the same thing here. I think when it's going to be more publicly accessible than it would otherwise be, because not very many people are going to go through the trouble of going to the courthouse. We need to be more thoughtful about protecting our clients' privacy. I did want to share.
Can I just interrupt for 1 minute?
Yeah.
While it's on my mind, Judge Cunningham, I heard through my assistant, which may or may not be accurate, that as of May 1st, we could start filing regular motions and then wait for the court to tell us how it's going to be handled. Is that accurate? Meaning non-emergencies, just normal stuff. Well,
I guess I don't know what your assistant knows or doesn't know in terms of what she heard. When our court shut down, for example, well, it didn't shut down, but when we limited to essential functions only in response to the pandemic, matters that had been precipitated for hearing kind of still existed. So every Thursday when my staff gets the list of precipes, they would still have whoever had filed prior to the court limiting the ability to do so. I would assume that once the restrictions lift in terms of access to the courthouse, you'd be able to file precipes again. I haven't been made aware of or am able to speak to when that's going to be open, but I will say this to piggyback off that, and this does touch more kind of on our subject of what's an emergency. All of the judges, I believe, at least in Oakland Circuit, especially the family division, have updated their online protocols. So my protocols, and I think most of them, of my colleagues, have a spot that tells you if you want a motion to be heard, here's the things you need to communicate to court staff, here's the email addresses, and the language is identical to the precipice language. So it's your certifying contact that you've made, you made contact with the other side and concurrence has been denied, that you're requesting a Zoom hearing of all the contact information, that all that's in there. So in the short term, if that gets extended, that you're not able to file precipes, our protocols will tell you how to file, or at least get the court's attention that you are trying to file a motion and you'd like it to be addressed.
Thank you. It's helpful.
I can tell you too, as far as filing motions, Livingston County is accepting all motions. They have a drop box outside of the courthouse, and they also have an email, so they are accepting pleadings. I have actually scheduled some things for hearing when I think the shutdown's going to be over, and if my date is wrong, they just call me and tell me to renotice it. So they are accepting everything.
And we are accepting everything as well. The main court page has the information that's got an email address for the clerk's office to file. It was originally just for emergency motions, to come back to what we're talking about today, but I think it will accept filings on all matters too. And additionally, we have gone e-file on all domestic cases. So DMs, DOs were already e-file, but DMs, DCs, DZs, DSs and DPs, everything is e-file now. Cases, I believe it's 2016 through current, were automatically uploaded. Anything prior to that you're trying to file a motion on, you'd have to kind of, I think, sign up for e-file for that case. Now, that doesn't automatically sign up the other side, but in terms of getting something filed, that when you e-file something, that'll go right to my clerks or any of the other judges' clerks as well.
Judge, if I could ask you something to touch on what my clients have been asking me about, particularly related to the COVID and the contact and the parenting time. I hope I'm telling my clients the right thing. What have you been doing in those situations with the first responder parents and the other parent is nervous?
Great question. So, and we all have been getting a lot of that. That is, and I'm sure if I could see everyone's face, I can't, it's going to be a chagrin moment, but it's a case by case basis. I guess I'll start with this. If there's a way, if someone is a first responder in terms of, this pandemic's definition of a first responder, someone who's in a hospital, someone who's working at a grocery store, or another essential business, and they're interacting with the public, with all the safeguards in place. I would start with this. What's the safety plan? As if this was kind of like a CPS issue. What's the safety plan here? Is there a way that this person can go to work and still come home and take all the safeguards and the reasonable precautions that they can to prevent contamination inside the home? So maybe that's, they come through the back door, the mudroom door, and they completely change their clothes. They go right up, they take a shower, the clothes go right into the wash. It's what can we do to minimize impact in the home? Because here's the thing, the governor's orders still specifically address compliance with court orders and compliance, especially with parenting time order. That's in there for a reason. And so to the extent we can still comply with parenting time orders, we should. I just got up a hearing myself where I said, listen, everybody's scared. Everybody is grappling with this, and everyone's got a heightened level of anxiety, and adults and kids. And the kids are picking up on this just as much as the adults, and they know it's weird that mom is all of a sudden, stripping down in the back room and throwing all of her clothes in the wash. But they're going to be okay. They'll adjust to that. But it's what can we do in place? If there's no reasonable way for us to protect the biological sanctity of a household from a first responder, that might be a discussion about, all right, what do we got to do about parenting time to make it so that we're not creating an unreasonable or unnecessary risk of exposure.
Right. That's a really good idea, Judge Cunningham. So I just wanted to share really quickly the little bit that I was able to find from the State Court Administrative Office. And I'm sorry, I didn't print out the first page. I have it on my COVID-19 resource page, which I will put a link to that in the chat. But I just printed out the page that was relevant to family law matters, and it's a very short section that deals with family law matters and to answer the question, what is an emergency? Ex parte, when you need ex parte relief in domestic relations proceedings necessary for the safety and well-being of a litigant or children. So I don't know and that just cites 3207, which without pulling out the court rules because they're at my house now, but without pulling out 3207, I think that probably does tie into the irreparable harm standard that Judge Cunningham, you mentioned, because that's like the court rule that covers TROs and whatnot. Then there's a bunch of stuff, pardon?
I believe so, yeah.
Yeah, and then there's a bunch of family court matters that we're not talking about today, specifically like child protective proceedings and friend of court arraignments. And then it says, all other family court matters, including trials, must be conducted remotely using two-way interactive video technology. And then the last category is other emergency motions in the discretion of the court. So really that is the line, that the two lines, the one that's ex parte relief for domestic relations for safety and well-being, or other emergency motions in the discretion of the court. And then everything else needs to be done remotely. And so, I feel like there's a tension between what some counties are doing, and only some counties, I've heard from multiple sources, are only hearing what they deem to be a quote an emergency, whereas other counties, like I'll just use Ottawa County as an example. I don't believe Judge Van Alsburg is on the call today, but if he is, he's more than welcome to unmute himself and join the conversation. But he, from the very beginning, Ottawa County was having hearings on all kinds of matters via Zoom, not just emergencies. And there's like a huge dichotomy in the state of how the courts and each individual judge is handling it, which is making it, I think, complicated and probably a little frustrating for family law attorneys when from one case to the next, an attorney can't figure out what they're going to be able to get for relief for their client to even get it heard. We did have a brainstorming list of different types of possible emergencies. So we've already talked about a couple of them as we've been talking here this afternoon, but I'm going to start throwing out some others and would love to have the feedback of the panel of whether you think it qualifies or not. We already talked about parents who are working in a high risk field, and Judge Cunningham addressed that. What about the parent who is leaving the child with other relatives while they're going to work? I mean, they could be an essential worker at a grocery store, at a hospital, what have you. But there's some parents are like, well, if you can't be with the child during your parenting time, you shouldn't be leaving the child with somebody else, whether it's a relative or non-relative that's not living in your household. It either should be my house or your house. It can't be anywhere else or with other people. I don't know, is that an emergency if that sort of thing is happening right now?
I can't answer that. I think I'm not a judge, but if I am a parent, and I think I would feel very uncomfortable and try and give some relief from that if I didn't know where my child was, especially if the child is not old enough to express himself or herself. And I understand both sides of this because I've thought about it and I have been questioned about it. So my advice is basically, I'll try to do what I can for you. In the meantime, you're going to have to just obey the order and let's try and, find something out from the court. It's a real problem for me when you don't know where your child is, or who's coming in and out, especially in this atmosphere. There's so many, look at the people in Lansing that were driving around the Capitol. Lisa knows that for sure, and honking their horns, and they were all getting out of their cars. And there's a lot of people who aren't taking this serious at all. So, I can't tell a parent, I can't do anything. I'll try to do what I can for you, but you got to obey the order until I can do that. We just have to work really fast.
And that does create an interesting dichotomy, because by obeying that custody order, you're then violating the executive order by not staying at home or within your household. I agree, one parent or the other, if one parent's going out, don't take them to a third household, because that violates the stay at home. It's obviously, you all know this, very frustrating in these cases with the litigants not having a lot of common sense, given that they're in litigation and concerned with fighting each other rather than thinking things out. But I would think that would be a problem because it's violating the governor's order.
But again, what do you do when you have a child that's not, that you can't know for sure that they're reporting accurately? Right. A 3-year-old or a 4-year-old, or, they say all kinds of things. I saw Auntie so-and-so might be that they were taken to the house, or might be on Zoom. You just don't know. And that's really problematic.
I guess I would say if to weigh in on this one, two things. One, if a parent doesn't know where a child is going, whether or not this is a COVID-19 situation, I would consider that some sort of an emergency, because parents have the right to know where their kids are when they're not on their parenting time. To the extent that there is a conflict between the governor's orders and a parenting time order in terms of whether or not we're taking children from what is normally daycare, or childcare provisions versus how we're handling things right now, I guess the parents need to come together on that one first. Everyone is ordered to stay home unless they are going out for life-saving measures, food, or they're deemed an essential worker and they have to go do it. So if there's a parent that's leaving to do one of those things that requires childcare, and although I absolutely cannot stand the right of first refusal languages and judgments, because what happens is the court lives with them a lot longer than the attorneys that helped draft the judgments that said right of first refusal, this is great. But that might be a discussion if hopefully if you got reasonable clients out there to say, listen, right now it's a weird time. Can you provide the childcare so we're limiting our child's exposure to multiple households or multiple places? In the event that none of that's possible, where there is a situation where you've got two parents both deemed essential, both have to be out in the community right now, and there's a need for childcare. Before I would be coming into court filing an emergency motion, I would be looking at what else is in there. What have we done? Here are the steps we've taken to arrange this. We've reached out to dad's mom, who is retired and able to do so. We've looked at all these options. When I think when judges see more options have been looked at before coming into court saying this is an emergency, it's easier for the court to say, all right, they've exhausted possibilities. Let's see what we can do to solve this one. But that there's a conflict there between essential worker parents and the whether or not childcare is happening out of the home. I guess I would say also any household that children are going to, it would get my attention certainly if that household is not following the stay home, stay safe order. If it's a daycare where there's 9 kids coming every day and the parents are coming in and out, that defeats the purpose completely. And I don't think that's necessarily appropriate right now.
So Christine Heckler made the comment about how parents who are working are allowed to have childcare, and it's not a violation of the order because it's specifically permitted to have care for minors, dependents, and elderly or other vulnerable persons. I think the point Judge Cunningham's trying to make is that, and this is what I'm thinking, how many houses do we want to have a child exposed to? So if we can limit it to 2 houses, then I think that's preferable. Limit it to 1 house if it's not violating a parent's right. And that's easy if you have an intact marriage. But for those people who have 2 different households, limiting it to as few households as possible is going to decrease exposure. And then I think, if you always have the kid going to a third person's house, it's always the same place and you can kind of secure what's happening there. That's maybe preferable than if you don't know how many different houses the child's being bounced around to, because it's like you're just making it greater and greater, by adding houses into the mix. I want to get to Kristen Wolfram's question in a second so she can unmute herself. But before I get to that, I have one more scenario I wanted to share with you. So, Detroit's been a hotspot in the country. And so when parents, maybe we have custodial parents who are out of state, and now it's time for parenting time with the non-custodial parent who lives in Michigan. And I've heard of parents raising objections to sending their child from a non-hotspot to a hotspot. And I don't know if if the case happens to be a Michigan case, do you folks consider that an emergency to maybe delay parenting time that would otherwise happen in not just anywhere in Michigan, but like a hotspot within Michigan, like the Detroit area?
I would say no, and I would go back with Judge Cunningham. If there are safeguards in place, just because you're in a hotspot does not mean your household is not staying safe. And that in and of itself, I would not consider a reasonable basis to deny parenting time, especially for an out-of-state parent, because if an out-of-state parent, they're not seeing the child very much as it is, because it's probably one of those school year summer situations.
I guess I'll say this too. The key phrase that I think needs to be part of these conversations, and of course it starts with your clients and not, they're having this discussion with their ex before they're calling you, I would hope. But is that make up parenting time. The key here is absolutely make up parenting time. This is not a situation where anyone wants to deny or take away parenting time. This is a situation that everyone is dealing with. It's completely unprecedented. It's, force majeure, so to speak, as far as what's going on here. And parents are going to make up that time later. And, I've had a few cases that have blown up, and then all of a sudden it's, wait a minute, you want 3 extra weeks in August? Oh, well, suddenly that looks a lot better. And they're comfortable with, not transferring between households, and everybody seems to calm down. And as far as the issue of out-of-state travel, the whole point of what I think the world is trying to do is limit movement so that this thing, in terms of the medical community, as far as the transmission rate between individuals, goes down. And so the theme being limit movement, if you have an out-of-state parenting time situation, that is movement. You're moving, you got to go to the airport. You've got to go to, you got to go pick up from the airport. You're getting on a plane. You're dealing with, there's a lot of risk associated with that. I would say out-of-state parenting time. I know it's hard, especially for the parent that's the out-of-state person, whether it's, they're here in Michigan or they're out of state of Michigan, but travel was one of the things that made this what it is to us today. And I think it's okay for everyone to take a pause, as we all are, to wait and get some makeup parenting time later, and we'll readjust.
One thing I was wondering, if, for parents who live quite a distance, is it safer to drive a long distance, or is it safer right now with limited flights to fly a long distance if you have to transport a child from one end of the country to the other? I don't know the answer to that, but I'm like, I kind of thinking it might be safer to fly because your exposure might be less than if you have to stop at gas stations or restaurants for, over the course of 24 hours as you're driving from one part of the country to the next.
And by the way, I had someone come, actually it was a grandparent coming to visit, and drove from Georgia to Michigan, and a lot of the gas stations don't let you use the restroom facilities, and a lot of restaurants wouldn't let him either. He was in trouble.
Wow.
So you got to kind of plan that out in advance if you're making a trip like that.
Especially if you have children with you.
Right.
So I want to go back to Kristen Wolfram asked a question pretty early on in our webinar about, what's the middle ground? If it's not an emergency, if it doesn't hit that high standard of irreparable harm or the standard under 3.207, but it's urgent enough that we can't wait for 3 or 4 months to get a decision on it. I think and I just wanted to address that topic, the middle ground question. I think a lot of counties are now dealing with those cases. I think the question is, when there's counties who are, and there are some still to this day, that are only hearing what they deem to be emergencies, what do you do? Any advice? Judge Cunningham, I know this doesn't mean, this is not your county, but if you had any thoughts for practitioners.
Sure, yeah. So I guess this is what I comes immediately to the top of my mind. Get creative. And what I mean by get creative is engage, do you have a good family counselor or parenting time and parenting time specialist on your case now with the front of the court? I know I've got an amazing team and I'm very blessed with them as well, but I would reach out to parenting time coordinators in your front of the court team or your referee. If there's a mediator in your community that is accessible that you might be able to get into, see if you can't get the parties to maybe talk about, listen, we're not gonna be able to get into court, but I think everyone can agree we need someone to help us out with this. Let's get involved with a mediator and see if they can maybe help out. And to the extent that one of the things I think we should also be cognizant of is some courts that are limited there, it's emergencies and essential functions. If you kind of rephrase the issue as this is an essential function that we need a ruling on, that might help you get some leeway there too with a court that you might not have as much access to as you normally do.
So I appreciate that, Judge Cunningham, and something that my habit has always been this: as soon as I have an attorney on the other side, is try and find a mediator for early mediation purposes. I think it's really critical, not just in these times, in all times, because so many times if you can just get the dialogue going between the parties, and sometimes it just takes somebody in between that's skilled at that to go back and forth between the rooms, and then the people suddenly think we could have done this without coming here. So yeah, I think having a mediator in place as soon as you can, so you have a second person that you can look to, even if you don't have a parenting coordinator or a GAL, that would be a good thing to do.
So another scenario that I've been approached with is where a non-custodial parent wants the summer parenting time to start right away because the children aren't in school anymore. And I think we really dealt with that issue when we did our first webinar way back, like on March 27th. But from an emergency perspective, I don't know, my feeling is it's not really an emergency that you want to have your parenting time start sooner. But hey, can somebody think of an argument that somebody can make as to why it should start sooner, just because of the simple fact that that the kids are, if it's true that they're not actually doing schoolwork anymore, because a lot of schools are still engaging and they're having assignments to do and whatnot.
This will be quick. No. And here's why. This is not an opportunity to reinvent the wheel. Children are supposed to be in school. In December, everyone had a calendar that said school ends on whatever day. And maybe that was going to get extended because of some extra snow days. Well, guess what? Maybe not. We've also had a very dry winter, and we all know when school is going to end. So stick to your schedule. This is not an opportunity to redo things that we, minus a pandemic where people are suffering, should be an opportunity to readjust your parenting time schedule. I would deem that not only an emergency, that would be, you're going to use resources where you're supposed to be limiting resources in situations in terms of your attorney, your home life, at the court to say, let's redo this. Now, if someone wants to agree, that's fine. But the expectation is that children are still in school right now to some degree, to the extent they can be. And you knew when that calendar date was, when school was going to end, and you should be comfortable with that date.
So what about, and if anybody is on the call from like any judges or referees from various counties around the state, if you want to pipe in and share what is happening in your county, I think we would all love to hear from other people. If you're not willing to talk out loud, you can put something in the chat, but we, welcome you to come share with us, because we want to hear what other people, what are people doing in the rest of the state? Not just representative of the panelists we have today. So I'm gonna, Christine Heckler asked another question, and Christine, if it's okay with you, I'm just gonna read it, okay? Have people thought of or confronted filing a motion for temporary custody in a new divorce? So this is where the divorce case is still ongoing when the parties are in lockdown together. It always creates tensions to file such a motion, but that tension is magnified and inescapable when the parties are stuck in lockdown in the same house and one parent has notice of a pending motion. So, I don't know if they're in the same house. I don't know what the point of a temporary custody order is, but I think that's anticipating that somebody's going to be moving up pretty soon, hopefully. Does anybody have any thoughts to share about those at least the interim orders that we're dealing with on the pending, the pending divorce cases?
I haven't filed such a motion, but I have a similar kind of reverse issue in one of my divorces. The parties are a newly filed divorce. Thankfully, there's no children, but they have to stay home, and these people are not essential workers, so they are staying home. And the one spouse is trying to force the other spouse to leave and threatening to call the police and claim abuse. So I think that could be abused to gain an advantage, just like the issue of starting parenting time early. Obviously on the flip side, there's a lot of domestic violence in these type of cases, but I think that could be very easily abused, like it is in my particular case.
Before I call on Michelle, who's going to give us an update for Wayne County, what your comment really made me remember, Tara, that I also wanted to bring up PPOs and the fact that PPOs should qualify, if you're trying to get a PPO at least, should qualify as an emergency. And I know that the state Supreme Court has basically extended PPOs so that people don't have to go back to court to ask for an extension if the time, usually it's a 1-year time period. If that time period is about to expire, I think they're getting an automatic extension on that now. Has any of the panelists dealt with any of the PPO issues?
Yeah, PPOs have been an interesting dynamic right now. Here's the thing. PPOs are about as serious of an order that we can all think of that they are. They're the definition of an emergency in the sense of they are, if one is being granted on an ex parte basis based on, someone filing some paper and before, of course, the pandemic, having interviewed with some of our clerks about their paperwork. That is a threat of irreparable immediate harm being granted. The effect of which is, and I say this a million times in court, affecting someone's ability to move about the community. It's kicking them out of their house. You're in a situation where if we're removing someone from a household under a stay home, stay safe order, where do they go? And what household are they going to end up at that there could be potentially exposing people to? So it's got even more heightened on both sides concerns for the judges. As far as the extension, there are extensions of timeframes for the expirations of PPOs right now, the automatic extensions, I believe. There's also extensions for times for hearings for these cases right now, but they're serious orders. If there's a situation in a household where it does rise to the level of a personal protection order, that is an emergency order. I mean, the theme of this webinar is what's an emergency. If there's a valid PPO, that's one. But we've also been seeing, because now people can file from their home, we've been seeing things like, he doesn't let my dog out. We've been seeing, I mean, the filings have morphed even more so in terms of what people think are appropriate for personal protection orders. So they're still coming in, but if one is to be granted on ex parte basis, it is as emergent as it gets.
Do we know what the domestic violence shelters are doing right now? If somebody was in an unsafe situation and need to get out of a house, pending divorce, are the shelters accepting people? How does anybody know about that?
I don't know.
I do not.
If anybody has any thoughts, please put it on the chat and then we can share it with everybody. Michelle, you were going to give us a Wayne County update.
Okay, so Judge McCarthy updated the through the listserv what the judges are doing in Wayne County. We are accepting all motions in Wayne County. They're done by electronic filing, but not the typical electronic filing format. It's you do pay through GovPay and then fax and email your documents to whomever they need to go to, whether it's the judges or the front of the court. All of the instructions are on the court website, but we are accepting all forms of filings. However, hearings, other than emergency hearings, which have been happening, hearings are not expected to start happening really until May 11th. The referees have not been doing any hearings during this furlough. We've all been working from home, but have not had the capabilities to be doing the hearings. The expectation is that the judges and the referees will likely start doing hearings May 11th for normal proceedings. Those will be, it's my understanding at this point, we will be in the courthouse, but there will be no public permitted at that time. So all hearings, whether it be with in pro se litigants or with attorneys, will be by Zoom or call-in.
Thank you, Michelle. A bunch of people have posted on the chat letting us know about various shelters that are operational right now. Sarah, can you unmute yourself, Sarah Bauk, and you can just share your comment. And there's a lot of other people that have posted information about it. But Sarah's on a domestic violence shelter board, and if she's willing to unmute herself, where are you?
Hello, I'm unmuted. Hi, I'm on the board, and it's business as usual, except of course all possible social distancing and disinfecting and taking temperatures and screening people. But yeah, they're open. It's pretty much business as usual. So thank you.
And are the shelters accessible to parents with children as well?
Yes.
Usually? Okay.
Yes.
And so another example, Evelyn Calagero, I think, was willing to share an example. She did an emergency motion and it was able to obtain relief on a case. Evelyn, did you unmute yourself?
Yeah.
Oh, good.
I had one in Kent County, and the clerks were, immensely helpful. That was a starting point. They had a special email address just for the emergency ex parte motions. And this was a father who was misrepresenting his business as critical infrastructure, landscaping, and making his children go work at customers' homes. And so I filed a motion saying either temporarily suspend the parenting time or order the father to stop misrepresenting his business and make sure that the children are allowed to have their cell phones at dad's house and that the oldest child can have his car at dad's house in case they need to get out, and ordered dad not to retaliate against the children because of this. So I was surprised. I filed the motion on March 26th and got an ex parte order on March 26th. And what I used in the motion language was the standard under 3207 for the irreparable harm, the standard in the stay-at-home order that said regarding the children's health and welfare, and then used the stay-at-home order language, the letter saying that they were critical infrastructure, cited federal standards, which I couldn't find any place. So I attached the federal guidance, I attached the Michigan guidance, and like I said, I put everything in the motion that I wanted the court to know. And I used the documents as attachments. Oh, the kids were asthmatic too. That was a big problem. But I attached every document that I wanted the court to see so that nobody would have to go looking for anything. And it worked out just fine.
So Evelyn and other people who are obtaining ex parte orders, the court rule requires there to be an actual hearing within, it's either 14 or 21 days. So what's happening with ex parte orders? Are there hearings happening within the time period allotted by the court rules?
In my case, no hearing has been scheduled. The father has not requested a hearing. He's filed some strange response to the order, but hasn't asked for anything else, and no hearings have been scheduled. So that's the status of mine right now.
Anybody else have having obtained an ex parte order, is any input about whether you're getting another hearing? Of course, you'd have to, like Evelyn's case, he didn't object, so maybe you don't need a hearing at that point, but at least if there is an objection, anybody having hearings or getting them at least put on the calendar?
I guess I could throw out, as far as what we're doing in Oakland is, if someone's going to object within that 14-day window to an ex parte order, immediately at that point, we've got your contact information, since the only way to do that is to email it in or call us, or you can't just show up, put something in the Dropbox and disappear. So to that extent, I've been asking my staff and my great friend of the court team to do what they can to reach out to people to see if we can't get it resolved. But something came in, I know we're running short on time, but something came to my mind kind of on this subject that I wanted to share also. I know that most people's clients are dealing with support issues right now too, because a lot of folks are out of work, and even the folks that are still working, it looks different, or it's a reduced income, and we've been seeing a lot of motions regarding support. I don't like saying this, but it's kind of the only way that really we can operate is, the emotions regarding support, as though they are technically in the practical sense of the word emergency, since it's a drastic change very quickly. I think most courts are looking at it as you file the motion, and to the extent that once you get a ruling, it might be retroactive to that date, and there might be some sort of true up that we got to do. But support issues in and of itself, it's universal, but it's also not really an emergency. And again, my heart feels for everybody, but I think as a judge, we have to follow the law, and technically those issues right now aren't really rising to the level of an emergency, unfortunately, that's going to change a support order absent a hearing, unfortunately.
So I'm going to call on Kristen Wolfram and Liz Bransdorfer, if you can both unmute yourself. But in the meantime, if anybody has examples of counties where they're not getting hearings unless it's quote unquote an emergency, I'm aware that Washtenaw County is one of those counties. If there's any other counties that you're aware of, if you could raise your hand or put it in the chat so we can share that information as well. Kristen? She's not unmuted. Hold on a second. Oh, there she is.
Nope, I'm here, at least audibly. If you're asking about the ex parte, I had one granted kind of early on in this, and they did file an objection, and today I just found out that that objection hearing is being adjourned indefinitely. So in this particular case, we suspended Dad's overnight parenting time, which I know that he's not happy with. I've offered to work, with the other attorney and everything. But obviously the non-overnight is the non-compromising, like we're not going to compromise on that. And I guess I don't know what he's going to do, but in that particular instance, that judge is not doing Zoom hearings. He's not doing anything except, the ex parte was granted on the emergency basis, and it appears that we're not going to have a hearing.
What county is that?
Kent County.
And I'm aware of another case, Kristen, where a parent's time has been suspended and the judge he's not willing to do an evidentiary hearing by Zoom. And that's a whole different, I know it's a whole different can of worms. It's actually the topic we're going to be doing for next week's webinar, because there are some counties that are going to be doing Zoom evidentiary hearings. So we are going to cover that topic next week. But Liz Brandsdorfer, can you go ahead and share your thoughts with us?
Yeah, I had a brand new divorce case. We filed the complaint along with a motion for ex parte and emergency temporary order affidavit and some proposed orders in Ottawa County. We mailed them Monday overnight mail, so the court got them Tuesday. And I just found out during this webinar that they were signed and entered. I specifically asked for ex parte relief on the custody matter. Dad was arrested for criminal sexual conduct in the presence of one of the children, and Mom took off and took the kids with her, and we got our 10 days in Ottawa County, and so we could file, so she could be near her family. And the emergency temporary order, I had proposed that we wait and see if Dad files an objection to the requested temporary order. If not, the judge sign the order, and if Dad files an objection, then we have a hearing. Judge decided to enter that order as well. So my client can go back and get some furniture and some more clothes and stuff to set up housekeeping. She has moved to Ottawa County. She's, applied for work here. She's got a place to live here. Given what's going on, there's no way she's going back to where she was. So I mean, I think I agree with what was said before. You put everything in there that you think the judge needs to know to make a decision on your motion.
Probably without having to have a hearing if the judge wants, is that what you're saying, suggesting that if it's possible for the judge to make a decision because you've provided enough information without the
right.
without the hearing? Okay.
Right, and then recognizing that you're allowing for due process and that the relief is without prejudice.
Right. Well, we're wrapping up on time, so I wanted to invite our panelists if they had any closing thoughts to share. Tara?
I don't have any closing thoughts. It's frustrating to hear the different things that are going in other counties. Some of them are being very progressive, but I think we're getting there.
Donna?
I don't really have anything other than to say one other thing that did come to my mind during the webinar was the special problems that are presented when you have a improper person on the other side. Because if that person just doesn't cooperate and won't open the door to get served, or, who knows about mail, then you're kind of left hanging there. But again, I try and use mediation and try and reach out that way, even with a letter to an improper.
Judge Cunningham?
Well, I guess I'll just say this. First of all, thank you, Lisa, for...
Oops. I lost his voice. Can anybody else hear him?
He froze.
No.
Look, Judge Cunningham, we lost you. Uh-oh.
All right, I just wanted to say thank you so much. If you could still hear me, I appreciate
we can now.
Everybody. All right, thank you so much for inviting me. And as far as the Oakland Circuit Bench is concerned, if you do have emergencies, I guess our protocols would be the first place to go. Our staff attorneys would be second. Thank you all for doing this work out there in this really challenging time on behalf of your clients. It helps you guys, helping your clients helps us do our jobs as well for them. So thank you very much.
Thank you to all three of you. Really appreciate your time today, and looking forward to seeing some of you next week at our evidentiary hearings by Zoom webinar.
Thank
Bye-bye.
you, Lisa.
Thank you.
I'm gonna stop the recording and then people can